All right, come here. I want to show you something really quick. And this is basically a case that was really important. It taught us essentially about what will trigger a DDS rep to go ahead and begin an investigation related to your benefit. And the bottom line with this situation is that you want to stay away from things that are going to trigger a Social Security disability benefit investigation. They have this group called CDI units. They investigate you, they follow you around, they interview basically people that you know, shops you go to, etc. This case right here will actually show us and teach us a little bit about that. Howdy, Jarhead Ed. Howdy, Kosherish. Howdy, Lisa Boston. Tristan Miller. Excellent. Let's get into it. So the basic claim here, I'm just going to give you some of the details. I'll walk you through exactly what it is. It is civil number 6:10-CV-06097. Again, civil number 6:10-CV-06097. This is James Schroeder versus Michael J. Astrew. Of course, Astrew is the commissioner of the SSA, and this claim teaches us essentially about where the SSA will go ahead and be triggered to essentially review your butt to see if you're still disabled. Let's go through it real quick. This is in the United States District Court of Western District of Arkansas Hot Springs Division. Let's get into it. James Schroeder, plaintiff, brings this action pursuant to Section 205G of the Title II of the Social Security Act. So he's saying, I bring this action as a plaintiff against the Social Security Administration Commissioner. I'm suing the SSA Commissioner. So that bottom line, he will go ahead and bring an action, a lawsuit against the commissioner for Social Security disability insurance benefits. Cool, you got it. Let's hit it. Seeking judicial review of a final decision of the commissioner of the Social Security Administration. So he is suing the SSA for the decision they made about his Social Security disability benefits, denying his application for disability insurance benefits and a period of disability under Title II of the Act. So he's pissed. He's suing the SSA commissioner for essentially, something that happened where they denied his disability benefits under Title II, which is your regular disability benefits. The parties have consented to the jurisdiction of a magistrate judge to conduct any and all the proceedings in this case, including conducting the trial, ordering the entry of a final judgment, and conducting all post-judgment proceedings. So both the plaintiff, James Schroeder, and Michael J. Ashrew, the commissioner, by and through his attorneys, have agreed to use a magistrate judge to handle all the matters related to this adjudication. So everybody's on the same page. Jurisdiction is cool. Let's get into it. Pursuant to this authority, the court issues this memorandum opinion and orders the entry of a final judgment in this matter. Okay, cool. Background. Plaintiff are James Schroeder, somebody seeking disability benefits, protectively filed an application for disability insurance benefits on December 3rd of 2007. Plaintiff alleged he was disabled due to depression. Plaintiff alleged on his onset date of August 1st, 2005. Now remember, back then, being found disabled was like really super duper easy. This is essentially, not when the SSA was super well developed when it comes to investigating people with the CDI units. They weren't set up. They weren't all over the place. It's one of those situations where, at the end of the day, they were just kind of getting ramped up. Because remember, the big ramp up period was in 2001, where, they started to see some fraud pop up as a result of the 9/11 scandal that happened with a lot of those, individuals that were police / firefighters. Now, ACC, thank you for the $4.99 donation. Let me put a little heart on that. That's awesome. Kisses to Shadow and Sweetie. Shadow is directly to my left on pillow number 1. And pillow number 2 is over there, and that's where Sweetie is. She is sitting on pillow number 2. I was actually really lucky. My parents and sister were up here a couple weeks ago. They took a look at one of the pillows that they lay on, and they were like, no, this is terrible. They took it, they threw it out, and they got me a much better one. So Sweetie and Shadow actually now use that one. But the other one was kind of pushed down, so they're watching out for those little chubby piggies. But I've got them right here. Shadow's going to be going for surgery real soon, but I'm going to do a video specifically on that. And also a video on essentially the future studio for disabled individuals to have a shot to use the absolute best gear in the audio industry and video industry. Well, I don't have the best video gear, but the best gear in the audio industry to actually show off their talents. It's going to kind of be like your classic, singing show, playing show, but essentially it'll be for disabled individuals. So I'm really excited about it, but it could be a total flop. We'll see what happens. All right, here we go. Plaintiff protectively filed December 3rd, 2007, AOD, alleged onset date, August 1st, 2005. The application was denied initially, and again, upon reconsideration, thereafter, plaintiff requested an administrative hearing on his application, and this hearing request was granted. So you guys know how it goes. Initial filing, get a denial. Reconsideration, get a denial. ALJ hearing, get a denial. Appeals council, get a denial. District court. Cool. All right, here we go. Plaintiff's administrative hearing was held November 25th, 2009 in Hot Springs, Arkansas. Plaintiff was present. It was represented by counsel Shannon Muse Carroll. At his hearing, plaintiff, his wife Shirley Schwitter, and vocational expert David Elmore testified at his hearing. At the time of his hearing, plaintiff was 57 years old, which is defined as a person of advanced age under 20 CFR section 404.1563, and had a bachelor's degree in business marketing. Now, we're looking at basically 57-year-old grid out based potential claim, if not vocational allowance. He's obviously not severe enough because this whole thing happened to have a listing level or compassion allowance listing. So he's shooting for a grid out. He's shooting for a vocational allowance. Okay. On March 3rd, 2010, the ALJ entered an unfavorable decision denying plaintiff's application for DIBs. So basically the ALJ, the judge said, no, 2010 March, you're not disabled. I don't think you're that bad. Yada, yada. Okay. In this decision, the ALJ determined plaintiff met the insured status requirements of the Act through June 30th, 2011. So the problem is, just to be very clear, June 30th, 2011, the bottom, whoa, wow, that is a massive donation there and absolutely incredible. So real quick, everybody, ACC did a mega massive $199.99 donation, which is absolutely incredible. Wow, that's huge. That's super big. That's mega big. That's huge. So that is wow. So I'm tempted to show you all Baby Shadow because that was such a massive donate. Do you guys want to see Shadow? He's right there. He's not really doing anything. Hold on. Do you guys want to see him real quick? Hold on. Let me see if I can grab him. Then we'll go back to the case because that was a massive donation right there. Hold on. Let me grab him real quick because that's absolutely. I'm on a giant high up chair that has to be affixed. So give me 1 second. Hold on. So here we go. Real quick. Hold on. Okay. So. Okay, so some of you are wondering what's going to be happening with Shadow in the not too distant future. Shadow is going to be going in for surgery, specifically on his hip. Let me get the chair. And what's going to happen is Shadow is going to be having a full hip surgery on his back right leg. And the thing is, Shadow, and I know you can't really see him at the moment, but let me see if I can go ahead and get this kind of cleared up. Shadow is basically, he's not that old. He's not that old, but basically he is getting ready to go ahead and have this giant surgery. And I know you can, sorry, the mic's in the way. Let me put this like this. Here we go. But, let me pull him in a little. So the basic thing is that Shadow is going to go ahead and have his back leg basically do a full hip replacement. And he's already falling asleep. Like, look at this. He's already like whatever. he's already asleep for this video. So, okay. You okay? You awake? You got gooey eyes? I know. I give you gooey eye medicine later. Okay. So basically, we're going to be going all the way to Ohio to make sure that Shadow, essentially, he's already falling asleep. He's like, I don't know if you guys can see this. I'm going to pull this down a little bit. But this dude is, he's done. He's like, I'm falling asleep. He's literally asleep right now. That is how entertaining Social Security law is. Oh, he's awake. He's awake. But he's going to be going in for major surgery. And I've been making outlines as to all the things I have to do to make sure he's going to be safe and okay. And it is a massive journey. It is 18 to 19 hours north and then 8 hours west to just go and get this surgery. But he's my kid. He's what I got. This my baby. This is my little sugar plum. It's my little snuggy snug. He's literally asleep right now. This blows my mind. Look, I don't know if you can see this real quick, but he just woke up. There's the baby. There's the baby right there. I know, Papa. I know. So with that said, without further ado, let me get this off cord. I'm going to put him back on the bed because he's adorable. And you notice I didn't pick up Sweetie because she's like 90 pounds. Remember cute little Sweetie when I first got her? She was this adorable little thing. And now she's just this monster of a chubby dog. Let me get him up real quick. Hold on. Oh, and here we go. Okay. Let me get him over here. Here we go. Okay. All right. Here we go. Impromptu doggy moment. Okay, so that's Shadow. And the bottom line is major surgeries coming up, which I'm super stressed about. And it is just, it is rough. But super thank you to ACC. I think I know who that is, obviously. But super thank you because bottom line is this. The doggy's super important. I'm sorry if you're not into dogs. We're doing a segue there, but we'll go back to the case law right now. All right, let's rock and roll. So here's the deal. Plaintiff's administration hearing was held November 25th, 2009. Plaintiff got denied. March 3rd, 2010, the ALJ entered unfavorable. ALJ determined plaintiff had severe impairments of depression and anxiety. ALJ also determined plaintiff's impairments did not meet or medically equal the requirements of any of the listing of impairments in Appendix 1 to Subpart P. All right, so basically what happened was the judge decided, okay, real quick, that the claimant wasn't disabled. Now, what happened was the judge had some evidence in the record that the claimant wasn't too happy with. The claimant was super pissed about this. In his decision, the ALJ evaluated the plaintiff under the subjective complaints and determined his RFC. First, the ALJ evaluated the plaintiff's subjective complaints and found his claim limitations were not entirely credible. Second, the ALJ determined plaintiff retained the RFC to perform full range of work at all exertional levels, but he's restricted to unskilled work in which he is limited to performing simple, routine, repetitive work with 1 or 2 step instructions. He must be in a supervised, low-stress environment, which requires few decisions, and he is limited to occasional interactions with public coworkers and supervisors. Okay, so real quick, the judge said, look, I think this guy is limited, but I also think he's a fibber. I think he's a liar. That's what the judge is saying. Judge is saying, I think this person is being disingenuous, and here's why. When we flip the page, we start to get into the spicy stuff. Here we go. ALJ evaluated plaintiff for past relevant work. Okay, ALJ determined plaintiff PRW included work as a general manager of a restaurant. Based upon his RFC, the ALJ determined plaintiff would be unable to perform as PRW. ALJ, however, also determined there was other work existing in significant numbers in the national economy plaintiff could perform. The ALJ based its determination upon the testimony of the VE. Specifically, the VE said, look, 1,600 jobs here, 185,000 jobs there, blah, 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 blah. Thereafter, plaintiff, who didn't like the judge, was super pissed about the decision, requested the appeals council review the ALJ's unfavorable decision. Cool. Case standard, nothing new, pretty much straightforward. The appeals council declined to review this unfavorable decision on December 7th, because appeals council could do that. Just be like, whatever, we don't see anything, no problems, whatever, you know what I mean? On December 17th, 2010, plaintiff filed his pro se appeal. The parties, now that's something to right there. Plaintiff filed his pro se appeal. Okay. So he couldn't find an attorney to represent him. Like, just keep that in mind. Like, that's something, a pro tip, be aware of that. The parties consented to the jurisdiction of this court on June 15th, 2011. Both parties have filed appeal briefs. This case is now ready for decision. Okay. Applicable law. All right. So now you understand the background jurisdictional. You understand where the docket went, right? He got denied initial filing, got denied on reconsideration, got denied at the ALJ hearing. Appeals council said, we're not even reviewing it. He filed pro se at district court because he couldn't find an attorney. Now you got it. In reviewing this case, the court is required to determine if the commissioner's findings are supported by substantial evidence. Substantial evidence is less than a preponderance, blah, blah, blah. We're not going to go through the standards with that stuff. I mean, maybe you know it, maybe you don't, but it's not relevant here. Okay, so we're going to go through this other junk. Hold on, let's get to, all right, here, the discussion, okay? All right, here. In his appeal, plaintiff's sole claim is that the ALJ erred in reviewing the Cooperative Disability Investigation Unit report that was prepared on plaintiff. Okay, so basically, the plaintiff is super pissed that the ALJ reviewed this document and made a mistake. In response, the defendant argues the ALJ did not err in any of his findings. So basically, the commissioner's lawyers on behalf of the SSA says, no, we didn't make any mistakes. You're full of it. Shoo, shoo, shoo. No, you're wrong. Cool. As the ALJ discussed in his decision, a hearing officer with Arkansas Disability Determination Services became suspicious plaintiff may have violated the act by applying for disability benefits while he also maintained a flower shop business with his wife. That sentence right there, let's read it again. It's important. If you miss it, you might lose something here. Okay, here we go. As the ALJ discussed in his decision, a hearing officer with Arkansas Disability Determination Services became suspicious plaintiff may have violated the act by applying for disability benefits while he also maintained a flower shop business with his wife. Okay, so I want to make something really, really super clear. When you apply for disability benefits, if you own a business, this is in many instances going to trigger a CDI unit review where they will create an ROI document after watching you, following you, interviewing people that have bought things from you, etc. So let's expand this now. Let's put our attorney hats on. What are they really saying here? They're saying that a flower shop, maintaining it with your wife, whether you are managing it or owning it or whatever, they're looking at this and saying, okay, this business owner or this self-employed individual or this manager of this business is essentially breaking the law because he's working and doing these work functions to the level that he can go ahead and earn money, even if he doesn't pay himself enough, even if he pays himself less. Because, that's kind of the trick with a lot of self-employed people. They pay themselves what they want to so that they pay less taxes. That's like the gig, right? So the main thing to kind of keep in mind with this particular situation is that they get triggered. The DDS reps get suspicious whenever they see you currently working, especially if you are managing something, especially if you own the business. So that's kind of your what's the likelihood of you getting, essentially reported to OIG, Office of Inspector General, to be reviewed? If you are essentially applying for disability benefits and they're reviewing you and they find that you're managing a business or owning a business, they're probably going to send out an investigator to go ahead and take a look at you. Okay. This is also the case in some parts, in some stylistic approaches to how they do it once you're found disabled. If you are found disabled, and the vets get in trouble with this stuff because the veterans, the Veteran Affairs Association is like, yeah, start some nonprofits, build it up, make it awesome, help the vets. And the vets are like, cool, I'm disabled, I'm going to try this. And then the SSA comes in and they're like, hey, wait a minute. Are you running a business as a disabled person receiving SSDI benefits and 100% compensation PNT and TDIU? They get into that like, hey, what are you doing here? Because, with VA benefits, if you're TDIU, they expect you not to be able to work, but there's some wiggle room on the whole non-profit-y thing, you know what I mean? And then, of course, 100% PNT, you get into that as well. But the point is, the systems on the VA side are much more loose with the allowance of you trying to go ahead and do something, try something. Whereas on the SSA side, you got your 9-month trial work period, your 3-month extended eligibility period, and your ticket to work program, your 5-year ticket to work program. You do stuff outside of those, man, you're on your own. You're steering a car that, potentially could go off the road. You know what I mean? I just want to do a shout out real quick again to the wonderful person who left the $199.99 donation, ACC, which is absolutely amazing. And also we have a new donation from AITCH, again, AITCH with the $4.99 donation. That's absolutely awesome. I love little pair with the ha. That's very, very good. So the thing I just want to go ahead and that was the third super on the live stream, which is absolutely awesome. So yeah, and please also remember to hit the like button. A lot of you guys, you don't hit the like button. You're just afraid to touch it. You don't want to shake it. You don't want to wiggle it. Give it a little tap. It likes a little tap. So with that said, what you have to understand here is you are watching out for, and I'll read it to you again, disability determination services became suspicious. You're watching out for that suspicious curiosity of the DDS rep. The plaintiff may have violated the act, broke the law, by applying for disability benefits, while he also maintained a flower shop business with his wife. Okay. So just to be fair, you own a business, you manage a business, any of those things, even if you have earnings under SGA, that is very, very likely to trigger essentially a Social Security OIG ROI report review, which is where they send that CDI unit after you. Not a good situation. As a result, the DDS hearing officer referred the matter for investigation to the Cooperative Disability Investigation Unit, CDI unit. On April 14th, 2009, two CDI investigators visited the flower shop and interviewed both plaintiff and his wife, Shirley Schwader. On May, if I'm reading it in a more Jewish style and you want to just, it's spelled SCHWEDER. If I'm reading in a more Jewish style, that's what I'm accustomed to. But if you have a different way to pronounce her last name, go for it. But to me, that's Shirley Schwader. On May 7th, 2009, CDI completed their investigation report. There was no finding plaintiff misrepresented his financial situation, which is interesting because, he basically said that he was, doing the flower shop and was what it was, etc. Now I want to point something out. Notice the timeline here. On April 14th, 2009, so middle of April, they started investigating. Okay. They visited the flower shop and they interviewed both plaintiff and his wife. Cool. Good there. Excellent. Excellent. Okay. Then on May 7th, 2009, okay, they basically finished. So they took around 3 weeks of a period of time to investigate and complete that ROI report. So 3 weeks. Normally I see them taking about 2 weeks of actual their time, and then usually 1 week of creating the ROI report, putting it together. So you're usually looking at 2 weeks of their interacting with the scenario, with the area, the geography of the place, and then 1 week to go ahead and make up the ROI report. That's what I usually see. Okay, there was no finding the plaintiff misrepresented this financial situation. Now, real quick, I want to do a big shout out over here to Sunny D Badoop. That is my favorite name out of everybody who has a channel, because how do you top that? Sunny D Badoop. You just can't top that. That's amazing. So it's $5 donation. Happy little fox with Bravo. Absolutely love it. That's amazing. And Christy Hughes, thank you with good questions on that last live video I did where I was answering questions. You got to catch me on the next live. I'm probably going to go live. I am tomorrow. So unless something happens, like I fall asleep or whatever, because sometimes that happens where I'm working. But Christy Hughes, make sure you give me a call tomorrow at that live session. Absolutely good questions for the blind community. Absolutely amazing. So with that said, super thank you to those two individuals. Please remember also to hit that like button if you could. So here's the deal. Although not argued, this court will treat plaintiff's only point of appeal as an argument that the ALJ erred in his credibility analysis of plaintiff by making reference to the CDI report. In assessing the credibility of the claimant, right? So he's basically assessing whether or not the claimant is a fibber, a liar. The judge is required to examine and to apply the 5 factors from Pulaski v. Heckler. Okay, this is important. Let me read it to you again. In assessing the credibility of the claimant, whether or not the claimant is a bullshit artist, the ALJ is required to examine and to apply the 5 factors from the Pulaski v. Heckler claim. Okay, and that was in 1984 8th Circuit. Okay, or from 20 CFR section 404.1529, 20 CFR 416.929. And then they also have Schultz v. Estru in there. The factors to consider are as follows. Number 1, the claimant's daily activities. Number 2, the duration, frequency, and intensity of the pain. Number 3, the precipitation and aggravating factors. Number 4, the dosage, effectiveness, and side effects of medication. And number 5, the functional restrictions. Okay, so these are the literal bullet points, the elements that they use to decide if somebody is, in fact, a bullshit artist. Okay, cool. The factors must be analyzed and considered in light of the claimant's subjective complaints of pain. The ALJ is not required to methodically discuss each factor as long as the ALJ acknowledges and examines these factors prior to discounting the claimant's subjective complaints. As long as the ALJ properly applies these 5 factors and gives several valid reasons for finding the plaintiff's subjective complaints are not entirely credible, the ALJ's credibility determination is entitled to deference, which means we gotta look at it, we gotta appreciate it, we gotta use it. So in other words, just to simplify, if the judge or the SSA thinks you're a bullshit artist, they use a 5-factor test to decide whether or not you are in fact a bullshit artist. 1, they assess the claimant's daily activities, the duration, frequency, and intensity of the pain, the precipitation of aggravating factors, sorry, my nose itches, the dosage, effectiveness, the side effects of medication, and the fundamental restrictions. Okay? These are the 5 factors they use to decide if you are, in fact, a BS artist in their eyes. Okay. Now, with that said, the ALJ, the judge, however, cannot discount plaintiff's subjective complaints solely because the objective medical evidence does not fully support them. So, in other words, the judge has to actually pay attention to what they're saying. The judge actually has to go ahead and say, hey, even though it doesn't perfectly match with the claim, I still have to take your subjective complaints and I still have to consider them, even though it might not match up perfectly with the rest of the record. Okay, no biggie, that's fine. When discounting the claimant's complaint of pain, the ALJ must make a specific credibility determination, articulating the reasons for discrediting the testimony, addressing any inconsistencies, and discussing the Pulaski factors. So just to be clear, the pain element, he's got to dig in on. Some of them he can floof around on, but he's got to, for the pain element, he's got to dig in on that one as to how they're complaining about their pain. Okay. The inability to work without some pain or discomfort is not a sufficient reason to find a plaintiff disabled within the strict definition of the act. Let me read it again. The inability to work without some pain or discomfort is not a sufficient reason to find a plaintiff disabled within the strict definition of the act. Okay, so it's saying, hey, I'm sorry, my nose itches because it keeps booping this a little bit. And I'm getting that, like, it's, what is it called? It's electrical. You know, it's like electrical. You feel like your nose, like, connecting with it. It's got that, let me just, there you go, boom. Okay. The inability to work without some pain or discomfort is not a sufficient reason to find a plaintiff disabled within the strict definition. The issue is not the existence of pain, but, okay, whether the pain a plaintiff experiences precludes the performance of substantial gainful activity. So they're trying to figure out if this guy could work, right? That's the end goal. Can this guy work? Okay. Note, there's a note here. I want to read it to you. Social Security regulations, 20 CFR 44.1519, requires the analysis of 2 additional factors. Number 1, treatment other than medication you receive or have received for relief of your pain or other symptoms. And 2, any measures you use or have used to relieve your pain or symptoms, like lying flat on your back, staying for 15 to 20 minutes every hour, sleeping on a board. Okay. However, under Pulaski and its progeny, the 8th Circuit has not yet required the analysis of these additional factors, which are in Schultz via Strew. Thus, this court will not require the analysis of these additional factors in this case, although they're good factors. They help. You know, sometimes they help the claimant. Okay. In the present action, the court finds the ALJ properly addressed and discounted plaintiff's subjective complaints. So in other words, they're saying the judge was correct in saying the claimant was a little bit of a BS artist and, you know, complained about his pain, but the pain wasn't actually that real. In his opinion, the ALJ addressed the factors from Pulaski and stated inconsistencies between plaintiff's testimony and the record. So the judge is saying, well, we went through the record, read the CDI report, the investigation notes, and we think you're a bit of a bullshit artist when it comes to your actual pain. Specifically, the ALJ noted the following. 1, absence of objective medical findings to support plaintiff's alleged disabling pain, which, by the way, when it comes to objective medical findings to show basically like that you have pain, some of y'all like to believe that if you go to the doctor can't fix it, and therefore you don't have to go to the doctor. No. You go to the doctor that is your general PCP. You go to the pain specialist, and you go to the emergency room. Again, general, specialist, and crisis. Those are your 3. You got your general doctor, your specialist, and your crisis medical documentation. Okay? Crisis medical treatment. One more time. General, specialist, crisis treatment evidence. Okay? Don't F it up. You F it up, you screwed yourself. Specifically, the ALJ noted the following: absence of objective medical findings to support plaintiff's alleged disabling pain. And 2, plaintiff's described activities of daily living are not that limited. So in other words, he's saying, number 2, Plaintiff described how he was limited, but in reality, he just wasn't that limited. Like, it just wasn't that limited. Number 3, plaintiff engaged in work activity after the alleged onset date, which is usually a big no-no for a lot of this stuff. You could do it. It could be under SGA. But again, if you're working, especially owning a business, after you allege that you became disabled, that's usually grounds for them to be like, hey, wait a minute. This guy's still, let's send out an investigator to take a look at this real quick. And element 4, plaintiff's use of medication has been effective in controlling his symptoms with no side effects. So essentially, whether it's over the counter or prescribed, if, you're saying, yeah, the pain medication works, I've been taking it for the past 6 months, 12 months, 13 months, 18 months, whatever, they're going to use that against you, because if you don't complain about your medication not working, then they're just going to say that it is working. Number 5, plaintiff's alleged functional limitations are inconsistent with the objective medical evidence. So in other words, he's saying, look, at the end of the day, this plaintiff, he claims he's bad, but the medical evidence doesn't show he's actually that bad. These findings are valid reasons supporting the ALJ's, the judge's credibility determination, and this court finds the ALJ's credibility determination is supported by substantial evidence and should be affirmed. Accordingly, the ALJ did not err in discounting plaintiff's subjective complaints of pain, and his limited reference to the CDI report was not error. So what they're saying is the judge is right, the claimant is wrong, is what it is, we rock and roll forward. Conclusion. Based on the foregoing, the undersigned finds the decision of the ALJ denying benefits to plaintiff is supported by substantial evidence and should be affirmed. A judgment incorporating these findings will be entered pursuant to Federal Rules of Civil Procedure 52 and 58. Bottom line, Barry A. Bryant, Honorable Barry A. Bryant, U.S. Magistrate Judge, decides the claim against the claimant. There you go. What did we learn? What did we learn from this case? Please remember to like and subscribe. Hit that like button. Don't be afraid of it. What we learned from this case was that at the end of the day, if you are a business owner, if you are a manager of a business, if you are underpaying yourself, these are usually things that the SSA looks for, that the DDS rep will have suspicion for, and they will refer your case to OIG for an investigation. And when they do that, they follow you around, they interview you, they talk to people who bought stuff from you, etc., etc. Okay, and there's ones, to be fair, you know what I mean. It's one of those situations where, at the end of the day, you know what I mean. I see disabled veterans on their boats fishing. You know what I mean, and some of them will say they got PTSD and it removes them from. But that argument with the SSA isn't going to fly. With the VA, it flies. It's fine. So you have to kind of know with each program what things they're going to be pissy about and which things they're going to just let it slide. Now, I will say this, the VA, Veteran Affairs, they're becoming more and more aggressive on just closing that fist on those people who are claiming they are 100% PNT disabled or TDIU disabled. They're definitely closing more aggressively on the veterans through OIG than they have before. I do believe the SSA and OIG are ultimately going to join each other on their path as to, restricting people or saying, look, if you are able to do these functions, you got to go get a job. So I do see those things in the future. All right. I don't like them, but I do see them. So anyways, I hope you guys had an amazing, amazing video. We have literally the next video about all the big changes that are going to be happening to Social Security benefits based off the statements made from the brand new commissioner, Frank Bisignato. That video is next. Please remember to like and subscribe and head over to Google. Type in Disability Resolution Law Firm or Disability Resolution Florida. Go ahead and throw some stars up there if you want. Totally up to you. I love waking up to them. I will catch you all the next video in about, I'd say, 5 to 7 minutes. Please remember Mondays and Thursdays, I try to go live to answer questions for free. And then also, final notation, if you need a private session where you get an hour of me, it's an hour, 10 hour, 15 minutes. There's a mini contract below. You fill it out, you send it in, you send the payment, and we're good to go. I will catch you a little bit later. We'll rock and roll from there. Attorney Walter Hnot, and see you in about 5 to 10 minutes at the next video. Thanks so much. Bye-bye. All right. Bye-bye, everybody. Bye-bye.